All right, looks like we have everybody connected. If I could have council unmute, please. Uh-oh. Okay, hold on a second. All right, now you should be able to unmute. Sorry about that.
Good morning,
Thank you
everyone.
very much,
Dan
Your Honor.
Harris on behalf of Harvin Lynn Kozelski.
Your Honor, my name is Tom Sparrow. I'm here on behalf of Angela Rose LLC.
Okay, great, thank you. We're on the record then. This is Emmet County case number 19106616. I'm sitting on this case by assignment. We're on the record this morning for a hearing on defendant's motion to disqualify presiding Judge Jennifer Deegan. I did receive the written submissions of the parties. I've had a chance to review those. So Mr. Sparrow, as the moving party, is there anything you wanted to present today by way of oral argument?
That's correct, Your Honor. Thank you very much. And let me just give you a quick background as to how we got here. Back in 2018, Angela Rose and Linda Kozelski, there was a dispute between the parties regarding the number of boat slips that were included in the sale. As a result of the dispute, the Kozelskis wind up suing Angela Rose LLC for trespass. She counterclaims for breach of contract. The case actually went to a jury trial in December of 2022, and both sides were no cause. There was a no cause of action on the trespass claim, and there was a no cause of action on the breach of contract claim. Notwithstanding that, Judge Deegan then orders Angela Rose LLC to pay $45,000 in attorney fees to the Kozelskis and their attorney, Dan Harris. Fast forward to 2024 in the fall, the Harris firms tries to execute on the award of attorney fees. They garnish the LLCs, they garnish Angela Rose's LLC's bank account, and they get about $1,600 out of it. That's when I got involved. After I saw this, I filed a motion for installment payments on the award of attorney fees. During this process, my client and I did a little digging and discovered that Dan Harris and Judge Deegan's husband, Jack Deegan, are what appeared to be very close personal friends. And that's based on a whole bunch of Facebook posts we uncovered, which are attached as an exhibit to my motion. They're summarized at page 2 of my brief. And, you know, I haven't had a chance to do any discovery, but at least up to this point, no one has contested that Dan Harris and Jack Deegan are close personal friends. And I think that's shown pretty explicitly in the Facebook page post, especially in the one back from 2011, when Mr. Harris says, "I want to punch Jack Deegan in the face." People don't say that on Facebook unless they're close, unless they're buddies. I mean, that's what men do. They tease each other. I think it's a fair statement to say that they're close personal friends. Based on this information, I filed a motion to disqualify. I filed a motion to disqualify because it's my belief and my client's belief that the relationship between Judge Deegan's husband and Mr. Harris creates an appearance of impropriety that requires her to disqualify herself under Michigan Court Rule 2.003C1B2, which says that when a judge, based on objective and reasonable perceptions, has failed to appear to the appearance of impropriety standards set forth in Canon 2 of the Michigan Judicial Code of Conduct, the judge must recuse itself, him or herself. That's my case in a nutshell, Judge. And if I can't, I mean, the easiest and most plainest way to say it is that in this case, Judge Deegan awarded $45,000 in attorney fees to her husband's close personal friend. If that is not appearance of then nothing is, Your Honor, in the code of conduct. And her response was, well, appreciation. But that's not accurate. Attorneys simply can't have a close person want to appear in front of the judge. That's
Mr. Sparrow, I got to stop you for 1 second because I think your signal's bad. You may want to just go to audio for a bit while you're making the argument, because I lost quite a bit, maybe about a minute of your argument there, the last minute. So
well, Your Honor, can you hear me now?
I can, yeah. The last part I heard was you were saying that Judge Deegan awarded attorney fees to a close friend of her husband, and then that's when you cut out. So I didn't get anything after that.
Sure, Your Honor. Thank you for giving me a chance to go back. But that's when the difficulty in this case started, is when, after both sides in the jury trial were no caused, notwithstanding the fact that both sides were no caused, she awarded $45,000 in attorney fees to the Kasuskis and Dan Harris, who was their attorney. And then what I said was, fast forward to 2024, when the Harris firm attempts to execute on the award of attorney fees. I filed a motion for installment payments, and at that point in time did some digging in this case and discovered that Mr. Harris and the judge's husband, Jack Deegan, are what appear very much to be close personal friends. And that appearance is demonstrated by the Facebook post that I included with my brief and have outlined. I summarized them on page 2 of my brief. I think they're very telling of the nature of the relationship. And again, up to this point in these proceedings, I have not heard anyone object or oppose a finding by this court that Jack Deegan and Dan Harris are in fact close personal friends. And so based on that, I filed the motion to disqualify. It's my opinion and the opinion of my client that the relationship between Jack Deegan and Dan Harris creates an appearance of impropriety when Dan Harris tries to practice in front of Judge Deegan. That is it's not permitted under Michigan Court Rule 2.003C1B2, which states that when the judge, based on objective and reasonable perceptions, has failed to adhere to the appearance of impropriety standards set forth in Canon 2 of the Michigan Code of Judicial Conduct, that the judge must disqualify him or herself. And so in a nutshell, Judge, that's what my argument is. That the fact that Judge Deegan awarded $45,000 in attorney fees to her husband's close personal friend creates an appearance of impropriety. And my primary argument here, Judge, is that if that's not an appearance of impropriety, then nothing is. And nothing would rise to the level of an appearance of impropriety, and the rule is meaningless. And that simply can't be the case. At the last hearing, I presented the same argument to Judge Deegan, and her response was, well, if this is the standard, then, we couldn't have a bar association. But I submit that's not correct. What we can't have is attorneys who are close personal friends to the husband of the judge, and then that attorney turn around and appear in front of the same judge, and that issue not be disclosed. At a minimum, this relationship must have been disclosed way back at the start of the trial. But that's essentially my argument, Judge. But let me leave you with, I did a little more research this morning and did find one more ethics opinion. It's Michigan State Bar Ethics Opinion JI 79. And the issue in this case was whether a attorney who practiced in front of the judge could be a member of the judge's reelection committee. And the State Bar went on to say, the need for the judiciary to avoid the appearance of partiality exists even in the absence of judicial wrongdoing or favoritism. In a democracy, the enforcement of judicial decrees and orders ultimately depends upon the public cooperation. The level of that cooperation depends on a widely held perception that judges decide cases impartially. Consequently, judges are called upon to avoid all activity that so much as suggests their ruling are tempered by favoritism or self-interest. And now if we take that statement and juxtapose it with what happened in here, in this case, where the judge awarded $45,000 in attorney fees to her husband's friend, I submit that there's certainly a suggestion of favoritism in that ruling, and that requires Judge Deegan to be disqualified from this case. And thank you very much for hearing me out, Judge, and thank you for giving me an opportunity to repeat what I had already said.
Okay, all right, thank you. Mr. Harris, any response?
I do, Your Honor. This case was tried before a jury in Emmet County over 2 years ago. And frankly, the judge didn't do us any favors during the course of that trial. And the Angela Pappy, that was the driving force in the lawsuit. And they asked the jury for over $450,000 against our clients. And in the counterclaim, we asked for $1 on the trespass. Okay. And so the award that she was looking for was $450,000, and she got no cost. Now, in the beginning of the case, we thought it was frivolous, exactly what this motion is. And we filed an offer of judgment for, I think it was $1,500. And then she went through a number of attorneys during the course of her case, and she ended up with a lawyer out of Farnham, Kyle Konwinski, who's a very skilled lawyer, very skilled trial lawyer, who tried the case for her. And when he got involved in the case and he saw that there was an offer of judgment, he did a counter offer of judgment right before trial. I don't remember if it was the 42 days under the court rule or not, but he did an offer of judgment for $100,000. So when he did the offer of judgment, that triggered the average offer for sanctions under the offer of judgment rule, which says that attorney fees shall be awarded. And that was the basis for Judge Deegan awarding the attorney fees, was under the offer of judgment court rule, which is mandatory. Really, it wasn't a discretionary thing. So then 2 years goes by and we're trying to collect on the attorney fees. And I would add that just a few months after this, Judge Deegan actually awarded attorney fees against my firm in a case where, it wasn't the same issue. And I actually still dispute that those should have been awarded, but she did. And when we go to collect on this, they file a motion for an installment, which you can't do because it's a corporation and not an individual. And then they come up with this motion to disqualify. Just because this counsel says that I'm close friends with Jack Deegan doesn't make it so. I am not close friends with Jack Deegan. I am friends with him on social media. I don't go out to dinner with them. I don't go to their home and socialize. I don't go on vacations with him, nor have I ever, like the case that was cited by counsel here. So he files this motion, which is frivolous, based upon facts that he is just making up, and they're doing it in an attempt to not pay the attorney fees that were awarded under the offer of judgment sanctions. So we live in small communities up here. I have known Jack Deegan for over 20 years, and the real basis of my relationship with Jack Deegan is he's on the other side of cases that I have. He does insurance defense. I do plaintiff's personal injury. And we have had a lot of cases, very contentious cases against each other. And that is the nature of our relationship. But because we live in small communities, we do know the lawyers and we do know the judges. And It doesn't form a basis for disqualification. We do this when we have jury selections all the time. When we ask jurors, do you know the parties? Do you know the judge? Well, yeah, everybody up here raises their hand, where if you're downstate, it's very unlikely. And so it's the nature of it. But, you know, to say that Judge Deegan should be disqualified because of acquaintance with Mr. Deegan when I have no real social or otherwise relationship with him is ridiculous. And I would add that, you know, the other lawyers of Plunkett and Cooney, who are actually his partners, I don't even think are disqualified to practice in front of Judge Deegan. So this motion is without any merit. It's without any legal support. The allegations that he's saying are actually not true. And the reason that they filed it was to delay the money that she owes, because her lawyer did an offer of judgment for $100,000 before trial. And you should award sanctions against him. Like, he's earned it.
Okay, all right, thank you. Mr. Sparrow, it's your motion. Anything in response?
Well, just a couple things, Robert. First of all, there's no small community exception to the canon of conduct that a judge is required to follow. There's no exception for the fact that you're up in Emmet County and the population isn't as big as, say, that of Wayne County. Second, with regards to the award of attorney fees, certainly Judge Deegan could have easily found that their offer of judgment in a case where she's seeking $400,000 in damages, their offer of judgment of $1,500 was de minimis. She certainly and easily could have found that and should have found that and didn't. Finally, I think the Facebook page posts that I have provided, and in particularly the post where Mr. Harris talks about the membership, the general membership of a group him and Jack Deegan are members of, and talks about punching Jack Deegan in the face. I think the posts demonstrate that they're more than mere acquaintances. I'm not impugning what he's saying, but the posts speak for themselves there, Judge. So that's my argument. I think she needs to be disqualified. And I'm asking this court to rule that she is disqualified.
Okay, all right, thank you. Again, I did review the written submissions of the parties, including the exhibits that the plaintiffs attached to their motion, the Facebook posts and so forth. I did have a chance to review the law and the ethics rulings and case law regarding disqualification cited by the parties prior to the hearing today. I find that the arguments of counsel here on the record today are generally in line with their written arguments, so I feel comfortable in ruling from the bench on this issue. First of all, with regard to a procedural matter, the court is presiding over this case pursuant to MCR 2.003 D3A, where a judge in a single court or a single judge court rules on a motion for disqualification. The parties have the ability to seek a review of that ruling by a court outside the jurisdiction, and thus this court's been assigned to hear this motion. The court's required to hear the motion de novo, in other words, without giving any deference in regard to Judge Deegan's ruling on the motion. Looking at the plaintiff's argument here, it's largely based on the appearance of impropriety, but both in the written submission and in Mr. Sparrow's argument today, I think there's an element of an allegation of actual bias as well with regard to the award of the attorney fees. So the court's going to address both of those issues. Where there is the potential for actual bias based on a personal relationship, such that it's essentially presumed, or the way the case law frames it, constitutionally intolerable for a judge to continue to preside over a case where the personal interest is so great that there's a risk of actual bias. And that's kind of, in my view, what the plaintiffs are alleging here. either there was some bias in the award of the attorney fees, or the relationship is such that Judge Deegan shouldn't be allowed to continue because it's so close that it would be constitutionally intolerable to assume that she could remain impartial or has remained impartial. Typically, under those circumstances, case law provides that there's some kind of pecuniary or financial interest of the judge. There's been some type of high level of personal abuse or criticism of the judge, where the judge is prejudiced due to some kind of prior participation in the case in a way outside of the judicial role. Those types of things characterize constitutionally intolerable connections to a case where the judge should be disqualified. Looking at a mere appearance of impropriety standard, that's where the conduct or relationships of the judge create in a reasonable mind a perception that the judge's ability to carry out his or her duties with integrity, impartiality, and competence is impaired. Case law is clear that courts are to apply a common sense kind of objective standard. So in other words, not in the perception of somebody connected to the case necessarily, but a reasonable observer who's familiar with all the facts and circumstances looking at that case, would that observer apprehend or be concerned about an appearance of impropriety? And so looking at the case law and ethics opinions, which were submitted by the parties, and the research that I did, I didn't find anything where the facts were directly on point with this case. So there hasn't been any opinions or case law that would specifically preclude Judge Deegan from continuing to preside over this matter. I didn't find any cases that were so close to the factual scenario here that it was black and white. So the court's going to look towards the ethics opinions that were close to this circumstance and at the facts and circumstances here. And number one, I find that while there are some allegations of some contacts directly between Judge Deegan and Mr. Harris or his firm, such as kids attending the same school and so forth, none of those, in my view, would rise to the level of creating any kind of risk of actual bias or appearance of impropriety. So it's mainly this issue, and as argued by the parties here, the issue of Mr. Deegan, Judge Deegan's husband, and plaintiff's counsel. In reviewing the Facebook posts, I mean, in my review as an objective observer here, those don't rise to the level to me of a close personal relationship. They don't refer to any kind of real substantial direct contacts or interactions between Attorney Deegan and Attorney Harris. They look to me like the kind of thing that you would post to somebody who's a Facebook friend, somebody that you're acquainted with, but not necessarily close personal friends with. I would think that if there was that kind of relationship, that Mr. Harris would more likely be calling Mr. Deegan or going out and having a birthday dinner or something like that, as opposed to just shooting a Facebook, hey, happy birthday kind of thing to him, or those types of messages. So in my view, those Facebook interactions to me appear to be much more in the nature of an acquaintance, somebody that you're familiar with, that you think enough of to send a message to, but not to the point of directly interacting with them for a particular event. So I don't find that those give rise to a finding that there's a close personal relationship. I think even if there was evidence that there was a close personal relationship, I don't think that necessarily imputes to Judge Deegan an assumption that she's going to be favorable to Mr. Harris. I mean, I don't mean to be flip about this, but I certainly have friends that my wife doesn't particularly like. So, you know, the fact that I'm friends with them doesn't mean that she would be favorable to them. And I suspect that the same may be true with Mr. Deegan. So I don't think even if they were close friends, we could assume that Judge Deegan would automatically be favorable to Mr. Harris just because her husband was friends with him. You know, there hasn't been anything to contradict Mr. Harris's statement that he and Mr. Deegan are frequently on opposing sides, which would again kind of tend towards a finding that they aren't close personal friends outside of the courtroom if they're frequently opposing each other inside the courtroom. The award of attorney fees in itself, even if it was a discretionary thing, there hasn't been any evidence that Judge Deegan, you know, routinely or regularly awards attorney fees in cases where Mr. Harris's firm requests them. Mr. Sparrow seems to be a very thorough attorney to me, and I suspect that he would have looked into that. And if there was a history of Judge Deegan awarding attorney fees on a discretionary basis to Mr. Harris's firm, I suspect he would have pointed that out. And so the fact that Judge Deegan awarded attorney fees to his firm in this case without evidence that she's regularly doing it or has ever done it before, I don't think gives rise to sufficient evidence to support a finding that that she was biased in this case and awarded attorney fees because Mr. Harris is friends with her husband. I would assume that being a law firm in Petoskey, that Mr. Harris's firm frequently practices in front of Judge Deegan, and that if she had a history of awarding attorney fees to his firm because of Mr. Harris's relationship with her husband, that would have been something that would have been pointed out. So the fact that it occurred in one single instance, which is all I have evidence of, again, doesn't give rise to a finding that that was a result of some kind of bias. And it certainly doesn't give rise to any kind of appearance of impropriety as defined by statute or by court rule, case law, and ethics opinions. So for all those reasons, and applying a de novo standard, the court finds that the motion should be denied. I don't think the motion is frivolous to the extent that it lacks arguable legal merit, and so the court finds that there isn't grounds to award attorney fees for the bringing of the motion. So the court is going to deny the motion to disqualify, and then the court is going to deny plaintiff's motion for attorney fees. And Mr. Sparrow, if you would prepare an order that reflects the ruling of the court today and submit that under the 7-day rule.
I certainly will, Your Honor. I appreciate the time and effort you obviously put into this. I really do. That was a very well stated opinion.
All right, thank you. That's all I have for today. All parties are free to disconnect at this time.
Thank you, Your Honor. Have a great day.
Thank you.